we've just had some technical problems. Mr. Sholland, I'm afraid that what you introduced this morning with has been lost because the broadcast sound wasn't working. So I wonder if you'd be good enough just to refer back to the case that you've been dealing with and then to move on from there, please.
Thank you very much, my lady. I was referring to the case of Humphreys and Rochdale, which my learned friend Mr. Watkin managed to track down. That's been provided to you. I also mentioned the fact that on page 6, paragraph 16, some of the lines are crossed out. That was not in the original text Mr. Watkin received, and that appears to have been added as a result of the scanning process. So those lines should be disregarded. And I will come back to Humphreys when I look at Lord Hoffman's judgment in Oxfordshire. Yesterday, my Lady Black asked me about public access to the TVG, and I want to briefly set out the facts in relation to that. Can I begin by turning to my written case at page 127? On page 127, at paragraph 7, I set out a quote from the inspector that was quoted by the Court of Appeal. And in that quote, he refers to the land in question being hard-surfaced, multi-purpose, publicly accessible area. So that's the first point. This issue is dealt with in more detail in the inspector's report. At paragraph 16.33, could I therefore ask the court to turn to page 472 of the electronic bundle, sorry. At page 472, paragraph 16.33, this is in the context of amending the application site. The original site that was applied for was far broader and included the area going up to the Swan Basin on both sides of the Grapevine. But because various bits of the original application site were publicly maintainable public highway, they were excluded from the village green. And at paragraph 16.33, the inspector details the parts of the site that were publicly accessible highway. The critical bit from this paragraph, I think, are fifth line, beginning the whole of the roadway down the eastern side of the Swan Basin to Allen's Quay, the whole of the route on the western side of the Swan Basin and descending to quay level along the southwest of the Grapevine. If I can show you what that means, if we go to the plan at page 305, you'll see the plan on at 305. You have the Grapevine buildings, and then next to that is the Swan Basin, and you can access the TVG from the high street, either going to the right of the Grapevine or to the left of the Grapevine. Those right and left routes were originally included in the application site, but were excluded by the inspector because they were highway. And you will see on page 305, at the top, there's a smaller plan, and it says highway, not highway, in relation to the original application site. So the highway was excluded, but you'll see there it gives access by at least two routes to the application site. Indeed, I think I inadvertently misled the court yesterday where I suggested that that was only pedestrian access. Having reread the inspector's decision, it appears that at least the access to the right of the Grapevine is wide enough for vehicular access.
Mr. Charland, you have vanished from view, at least as far as I'm concerned. I don't know whether you want to address that or whether you're happy to continue.
Pardon, my lady, I didn't catch.
You are no longer in view for some reason. I don't know whether you want to address that or whether you're happy to continue as we are at the moment.
Let me stop video and start video again.
Thank you.
I do apologise for this.
It's all right.
Okay. My lady, can you see me now?
I can see you now, and I think you've answered my question in this way, that in fact there is public highway access, either maintainable or not maintainable public highway access to the green. So
Yes.
that's the end of that point.
Yes,
Thank
my
you
lady.
very much.
I had one further point on this. If the local inhabitants did not have a right of access to the land, as TWL, the appellant, would have said, their use would not have been lawful because they would have had to trespass to access. This argument was not advanced by the appellant, no doubt because he accepted the local inhabitants did have a right to access the land. For your note, the appellant ran a related argument relying on some disused railway line which was embedded in the land. The appellant asserted that crossing that disused railway line that was not connected to the railway was trespass, contrary to section 55 of the British Transport Commission Act, and therefore use wasn't lawful. That was rejected by the inspector and Mr. Justice Barling, and there was no appeal against that. So the appellant was clearly aware of access issues, no point was taken. Yesterday, when I took the court to the facts, I detected some slight concerns about the factual position on this case. I would emphasise that unlike the majority of cases that have reached the Supreme Court or House of Lords concerning village greens, such as Lewis, Oxfordshire, New Haven, Lancashire, the present claim is not a judicial review claim or an application merely for directions pursuant to Part 8 of the CPR. This claim is brought pursuant to Section 14 of the Commons Registrations Act, and as a result, in this case, the court has the benefit of very detailed factual findings from an experienced Chancery judge who considered voluminous documentary evidence, able to hear live evidence over 6 days, including expert evidence, and had a site visit. So we say the court should pay particular respect to Mr. Justice Barling's factual conclusions. And we say it's particularly relevant to ground 3, which we say is a disguised attempt to challenge such conclusions. My lady, I now want to turn back to the law and paragraph 15 of the Commons Act that you will find at page 546 of the bundle. We've of course looked at this. Paragraph 1 says any person may apply to the Commons Registration Authority to register land to which this part applies. Of course, that's a reference back to the earlier section that says Part 1 applies, Section 5 that says Part 1 applies to all land in England and Wales other than 3 particular forests. Present application is brought under Section 15.3. There's no issue in relation to subsections 3B and 3C. What is, of course, critical is 3A. The language of 3A effectively replicates the language of Section 22(1)A of the Commons Registration Act 1965. The focus of subsection 3A is the past use of the land by the local inhabitants. The use of the past tense indulged make clear that what the registration authority has to focus upon when deciding whether to register the land is use prior to the application to register. For land to qualify for registration, all the elements set out in this subparagraph need to be met. In the present case, Subject to one possible caveat, we understand the position is now that it is common ground that all such elements are satisfied. Never been in dispute that the relevant locality was the civil parish of Mistley. There was an early stage dispute about whether the use was by a significant number of inhabitants, but that fell away. In relation to the lawful sports and pastimes for a period of 20 years, again, there was some debate about that, including the railway point and dispute of the lawfulness, but again, that fell away after Mr. Justice Barling's judgment. In relation to as of right, we say it's well established that this phrase is sufficiently described by the tripartite test, nec vi, nec clam, nec precario, not by force, stealth, nor license to the owner. The landowner has never suggested the local inhabitants' use was by stealth. The use relied upon is extensive, regular, and open use by local inhabitants. However, there was a dispute below about whether such use was contentious. It was said that the signage and the landowner's conduct was sufficient to render the local inhabitants' use contentious, and it was said it was also permissive, alleged permission implied by the landowner's conduct. The majority of these disputes fell away after Mr. Justice Barling's judgment. One matter went to the Court of Appeal, the issue of implied permission. That argument failed, and there's no appeal against the Court of Appeal's conclusion on that. So we say it's now common ground that all elements of the tripartite test are met. As Lord Sales put to my learned friend, the court in this case applied the legal test to the particular facts and concluded that the local inhabitants' use was as of right. And we say that's the end of the matter. And at times in the written case, the appellant appears to accept this. Could I ask you to turn up paragraph 31 of the appellant's written case at page 93 of the bundle? Paragraph 31, the appellant accepts that the majority of judges in Redcar said the test was limited to the tripartite test. However, ground 3 appears to be premised on a factual position contrary to this apparent concession. I'll of course come to ground 3 later. That's all I wanted to say on section 15 at this point. Can I now ask the court to turn to page 804 of the bundle? Where the court will find section 10 of the Commons Registration Act. This was in force in relation to Essex at the date of registration. Section 10 provides that registration shall be conclusive evidence of the matters registered at the date of the registration. It's common ground that the sole matter included in the registration is the fact that the land in question is a town and village green. Registration is conclusive evidence that on that date it was a TVG, and non-registration is conclusive evidence that it was not. This is discussed by Lord Hoffman in Oxfordshire, which I'm going to turn to very shortly. But that's all I wanted to say about the statutory provisions at this stage. I now want to turn to the key cases. I'm going to take them in chronological order. I'm not going to deal with each and every case my learned friend dealt with. Mr. Wold QC, who you're going to hear from after me, is going to address some of the cases, and particularly the principle of civilita. Mr. Wold and his junior, Mr. Eaton, have greater property law expertise, so they're going to focus on that. First case I want to deal with, I apologise. My lady, I can't hear you.
All right, sorry about that. It would be very helpful, at least to me, if you were to summarise first the propositions which we're going to get out of these authorities.
My lady, I will do so.
You can.
When I go through the authorities. The first authority...
Well, can we be very clear? Can you make sure that you give us the proposition at some point and identify it as such, rather than take us to a lot of citations.
My lady, absolutely. Can we begin with Fitch and Fitch? The broad proposition, my lady and my lords, I take from this case, this is obviously a common law case. It's not a village green statutory case. But the points I take from this, the principle I extract from this is that there must be give and take, and that the rights of both parties distinct exist together and must be exercised with give and take. My learned friend.
Just on that point.
My lady, I can't hear you again.
Okay, sorry about that. The customs in Fitch were specific customs.
Well, my lady, I'm going to come to that point because I don't accept my learned friend's analysis in this case.
Okay.
Which is the point I'm going to now turn to. As I understand the appellant's case, he says that both Lord Hoffman in Oxfordshire and the Supreme Court in Redcar misunderstood Fitch and Fitch, and they say it concerns a seasonal right, and therefore the rights of the landowner and the local inhabitants were thus not concurrent but sequential, and therefore the House of Lords and the Supreme Court failed to understand this. If we could look at the report, which we have at page 553, about a third of the way down the page, after the head note in brackets, if the case is about trespass for breaking and entering the plaintiff's close at Steeple Bumstead in Essex, the defendant justified that all the inhabitants of the parish of Steeple Bumstead had by custom a right to play at all times of the year, at all kinds of lawful games and pastimes in the said close. So what is the right being asserted here is not a seasonal right, except in Fitch and rulings, someone else asserted a seasonal right. But the report we have here makes clear that the defendant was asserting a right to play at all times of the year. And we have, in the bottom third, it says, Heath Justice, the custom appears to be established. This must be a reference to the custom referred to above, namely a right to play at all times of the year, at all kinds of lawful games and pastimes of the said close. The court goes on to say inhabitants have a right to take their amusement in a lawful way. It is supposed that because they have a right, plaintiff should not allow the grass to grow. No foundation in law for such a position. The rights of both parties are distinct and may exist together. If the rights were sequential, you wouldn't have this clash, because when the landowner's right to grow grass and make hay was an issue, the inhabitants would have no right to go on there at all. The whole case is premised on the fact that the rights are concurrent, and that's precisely what the report says. So we say the appellant is mistaken in his analysis of Fitch and Fitch. Yes, my lord.
What could they do when he was growing hay?
Well, the right claim was lawful sport and.
I suppose he could walk around. They could walk around the edge.
Precisely.
But apart from that,
walk around the edge with their dogs, or without a dog. Of course, there may be a gap. I don't know how this field was ploughed, but there may be a gap through the middle where the machinery means that you don't have hay growing. So there may be they may have been able to walk elsewhere. I don't know. We don't have much detail on the fact.
So take it on to another question, Mr. Sholland, and that is that if a green is registered, the green still belongs to the landowner, and the landowner therefore can control within the confines of what rights are being given to the recreators, can control the activity on that land. The ultimate decision maker is the landowner. As a matter of occupation, as a matter of legal responsibility for the health and safety of those people who come onto his land, that he has an obligation to control the activity on that land.
My lord, I accept that landowners may have health and safety responsibilities, and that's the point I'm going to come to when we look at ground one in more detail. Registration of the land as a town and village green means that the owner will not be able to exclude local inhabitants carrying out lawful sports and pastimes insofar as they're consistent with the landowner's use. That's what the Lewis Court, the Supreme Court in Lewis held. And we're also going to come to that case shortly.
So the landowner is the person who decides where and when things can take place that is consistent with health and safety regulations.
Well, the landowner's power to control local inhabitants' use is limited by the registration. So if clearly in the village green case we're looking at, the local inhabitants have a right to walk their dogs across it. I think it very much, we will look at the precise terms of the health and safety regime, because if you look at the terms, it talks about the employer taking steps as so far as reasonably practicable. Now, if the landowner's powers to take steps are limited by the existence of the village green, it won't be able to take those steps, and those steps won't be reasonably practicable. But of course, on the facts of this case, my lord, remember the landowner has granted a pedestrian right of way across both the Eastern Transit and the TVG. So regardless of whether there is a village green registered here or not, you are going to have pedestrians wandering over it, and also wandering over the more dangerous Eastern Transit.
We haven't seen that right of way. Is it to go in any part of the quay, or are they directed to a specific route?
We don't have. I referred when I took the court to the facts, reference to the right of way, but we don't have precise.
No, we don't know exactly how it was framed. Could I just put to you a concrete example, because I just want to be sure that I've understood what you're saying. I'll just go back to say that there was a time when badminton was very fashionable, and certainly in the Royal Courts of Justice, in its magnificent hall, in the evening after the building was closed, the officials of the court had very large pieces of green foam marked out with badminton courts, which they rolled onto the hall and had several badminton courts erected, including a self-standing badminton net, so that in the evenings they were able to roll it out and play badminton, and then roll it up again, and the next day life was as normal. When we talk about the right of the inhabitants now to have pastimes on the quay, suppose that they took the view that they would like to play badminton, and they bring one of these large green mats with the court laid out onto the quay and put up the badminton mat, and it's a Tuesday afternoon, and they don't think it's going to be used, so they start playing. Is it open to the landowner to say, I'm terribly sorry, we've got an urgent case, a ship coming loaded with fertilizer, which has got to be unloaded this afternoon. Please, would you take your badminton court away? Is that possible, or is it not?
Yes, it is absolutely possible, because the lawful sports and pastimes, pursuant to the Court of Appeal's decision and pursuant to the Supreme Court in Lewis, are limited by the landowner's lawful use. Now, my lady, you posited the question of badminton in the context of this key, but you could posit it equally on the golf course in Lewis. If you had local inhabitants setting up badminton courts on the golf course, that would interfere with the landowner's use, and it would be similarly problematic, my lady. Yes, Lord Burrows.
How does what you've just said then fit with Lord Hoffman's proposition that once one has allowed sporting and leisure activities of one type, it follows that they can continue, that is the recreators, in all sorts of other activities which previously hadn't been carried on? Is it a qualification of that principle that you're suggesting?
Lewis qualified that principle, my lord, yes. And that's how it was analysed in the Lancashire case. Lord Sale's judgment at paragraph 8 talks about Lewis qualifying that. It may be worth turning that up at this point. Page 655 of the bundle, my lords and my lady. This is taken from Lord Carnwath and Lord Sales' speech in Lancashire, and at paragraph 8, their lords summarise the position. Lord Hoffman in Oxfordshire talks about the one size fits all, but then goes on to say it makes clear that following registration, owner was not excluded altogether, but retained the right to use the land in any way which does not interfere with the recreational rights of the inhabitants, with give and take on both sides. That qualification was further developed in Lewis, in which it was held that the local inhabitants' rights to use the green following registration could not interfere with competing activities of the landowner to a greater extent than during the qualifying period. We say that's the ratio of Lewis, and it was just applied in this case. So that's our. I was on fiction. I've jumped from the first case chronologically to the last case, but those are my points on that. Let me just find where I was. I've just taken you to Fitch and Fitch and said my understanding is it was concurrent rights. That is also how Mr. Justice Sullivan understood the case. At paragraph 62 of his judgment, which just for your notice at page 1165, he said, in Fitch and Fitch, the inhabitants of a parish had a customary right to play lawful games and pastimes at all times of the year in the plaintiff's close. That was his analysis. So we say Lord Walker was right to describe Fitch and Fitch in the Redcar case at paragraph 29 as a forthright declaration of the need for coexistence between concurrent rights, because Fitch and Fitch was about concurrent rights and not, as the appellant mistakenly suggests, sequential rights. The approach of give and take articulated by Mr. Justice Heath makes clear that under the common law, the local inhabitant's right to recreate is not unlimited and cannot materially interfere with the landowner's right to use the land, in this case for the growing of hay. Of course, Fitch and Fitch is a first instance judgment, not binding on the House of Lords of the Supreme Court, concerns common law rights rather than statutory interpretation, and their lordships in Oxfordshire and Redcar were drawing an analogy with the common law position when seeking to interpret the relevant statutory provisions. Next case I'm going to take you to is the case of Lang, which is at page 1150. I want to address the point raised by Lady Arden. What proposition do I draw from this case? Well, my ladies, my lords, I don't really draw any proposition from this case other than the point I've just taken you to about the analysis of Fitch and Fitch. We say Lang is a decision confined to its facts, a first instance decision confined to its facts, and it's doubtful it's even correct on those facts. The Lang case is the genesis of the concept of deference. In this case, Mr. Justice Sullivan concluded that the use of the landowner, the agricultural use, was inconsistent with the asserted use by local inhabitants of the land for lawful sports and pastimes, and the fact that the local inhabitants deferred to the landowner's use at certain times was critical to his conclusion that use was not as of right. Now, Mr. Justice Sullivan relied on his earlier decision in the Lang case in the first instance judgment in Lewis. He applied this approach in Lewis, and of course the Supreme Court overruled that, rejecting his analysis and taking a completely different view of the issue of deference. And the Lang judgment, which my learned friend placed quite some reliance on, has been criticised and doubted by a large number of House of Lords and Supreme Court and Court of Appeal judgments. The first,
sorry, Mr. Before you move on, I just wonder whether the concept of deference informs what the previous use by the recreators was, so that after registration, they have rights, but those rights are subject to the previous deference that they showed to the port owner in this case, so that they are constrained to continue to show that deference and to take instructions from the port owner under that concept.
My lord, I would agree with that. We say that's what the Supreme Court in the Lewis case decided.
Yeah, thank you very much indeed.
So could I ask you to turn to, firstly, page 580 of the bundle. On page 580 at paragraph 57 of Lord Hoffman's judgment in Oxfordshire, he refers to the Lang case and says, in that case, land was used for low-level agricultural activities, such as taking a hay crop. At the same time, it was used by the inhabitants for sports and pastimes. No doubt the use of the land by the owner may be relevant to the question of whether he would have regarded persons using it for sports and pastimes as doing so as a right. But with respect to the judge, I do not agree that low-level agricultural activities must be regarded as having been inconsistent with the use of sports and pastimes for the purpose of section 22, i.e. section 15 now, if in practice they were not. Now, Mr. Justice Sullivan concluded otherwise. So Lord Hoffman doubts his conclusion there. In the Redcar case, paragraphs 26 to 28, of Lord Walker's judgment, paragraph 26, Lord Walker quotes Lord Hoffman in Oxfordshire, and then discusses what was said in the Court of Appeal in the Lewis case. And then paragraph 28, he said, that is not to say that Lang Holmes was wrongly decided, although I see it as finely balanced. So doesn't establish any broad principle, because that broad principle is inconsistent with the Supreme Court in Lewis and may well be wrong on the facts. It was finely balanced. Lord Hope, page 633, paragraph, sorry. 60 to 63, Lord Hope discusses the Lang-Holmes case. It notes that the concept of deference as a bar to the creation of a new town or village green is Sullivan Jay's creation. It was a bar in Lang, it was a bar in the Humphrey case following Lang, but it was not a bar the court in Lewis held. So that is what Lewis was about. Various quotes are set out from the judgment in Lewis, in Lang. Paragraph 63, referring to the previous passage, this passage suggests that Sullivan Jay was approaching the case on the assumption that registration was inconsistent with the continuing use of land by Mr. Pennington for taking the annual hay crop. In other words, registration would bring non-interference to an end. The public use of the land to use the fields for recreational purposes would make it impossible for them to be used for growing hay. His approach has also been taken as indicating that in cases where the land has been used by a significant number of inhabitants for 20 years for recreational purposes, next v, next am, next precario, there's an additional question that must be addressed, i.e., would it have appeared to the landowner for recreational would it have appeared to the reasonable landowner that the inhabitants were asserting a right to use the land for recreational activities in which they were indulging? I'm not sure that Sullivan Jay was really saying that there was an additional question that had to be addressed, but if he was, I would respectfully disagree with him on both points. The both points that are being referred back to is firstly the point about the additional question, and secondly the point made at the beginning of paragraph 63 about the inconsistencies and the problem that would cause. So again, taking issue with the approach in Lang. And finally, Mr. Lord Justice Lewison's judgment in this case, which is at page 203 of the bundle. Well, the passage I want to take you to is page 203. At the top of page 202, at the bottom of page 203, you have Lord Hoffman's, a quote from Lord Hoffman in Oxfordshire, paragraph 57, where he's talking about the Lang case. Paragraph 34, Mr. Lord Justice Lewison says, in Lewis, paragraph 63, Lord Hope said that Sullivan Jay was wrong in holding that continuing use of the land for the growing, cutting and drying of the hay crop was inconsistent with the effect of registration as a TVG. Made a similar point at 75. In the light of these observations, it seems to me that the Lang-Holmes case has been substantially devalued as an authority. A similar point is made at paragraph 71 of this judgment, page 212 of the bundle. I don't think we need to turn that up. Essentially, Lang is limited to its own facts, and it's doubtful that it's correct even on those facts. Can we now turn to the Oxfordshire case?
Just while we have the Court of Appeal's judgment open, will you be coming back to the holding by Lord Lewison at the end of 24 that those entitled to recreational rights must do so in a lawful way? Because that seems to be a rather careful use of language. But I think you're accepting from my badminton example, it means they cannot exercise recreational rights in a way which is inconsistent with the landowner's activities.
The landowner's pre-registration uses. So, my lady, if the landowner post-registration wanted to commence a new use that prevented the local inhabitants, it may well not be able to do that. But if in your badminton example that interferes with the pre-registration uses, yes.
So you look to see what's the nature of the activity, what's the test we're looking for? The nature of the activity, the nature of the business of the landowner. How do you define what is what is what he did in the previous period? It's not can't be a matter of seeing whether he used it on Tuesday afternoon to unload a ship.
No, my lady, I accept that. That in this case, the landowner has used the land in question for unloading ships. The TVG. We have in the inspector's report an analysis of how many tons were unloaded during the registration period. At the beginning, it was, I think, approximately 450,000 tons. That's dropped to now around about 170,000 tons. So within the registration period, he was unloading 450,000 tons, and he would be entitled to continue to unload that level.
But you've there limited it to the number of the tonnage. Sorry, you there limited it to the tonnage unloaded during the period, the 20-year period.
Yes, my lady. In the Lewis case, the court held that the landowner was entitled to continue their use, their goal here, for example, unloading ships, and that use could continue.
Without reference to tonnage. I mean, it doesn't say in Redcar you have to work out the number of hours of golf played.
No, my lady, I accept that. Applying the Court of Appeals approach, if there was to be some theoretical prosecution, one would be able to look at the inspector's report to determine the pre-registration uses by the landlord, and following the law in Lewis and the Court of Appeal in this case, that use would be lawful and there would be no basis for prosecution.
Thank you.
Thank you very much, my lady. Can we now turn back to Oxfordshire? The report begins at page 555 of the bundle. Before we look at the substance of it, I just want to respond to a point made by my learned friend yesterday, where he asserted that there was no argument about the effect of the Victorian statutes. And I believe the basis of that argument was there's no reference in the 6 pages of summary of the legal argument to that matter. But if one looks at page 555, it looks like there were 5 days of oral argument in the House of Lords on this case. So the 6-page summary will necessarily have missed out a lot, because clearly 5 days of legal submission cannot be summarised fully in 6 pages. In relation to this case, the principles I derive from this, the first one I don't think is controversial. Definition of village green is not limited by reference to its character. And secondly, the Victorian statutes have no relevance to the issue of whether land should be registered as a town or village green. I'm going to take you to Lord Hoffman and also Lord Scott on that point. I accept that's obiter, but we say it's correct. Leading speech in this case is given by Lord Hoffman, and my learned friends took you to this, and the first point, the character point, is at paragraph 37 to 40. My learned friend says, well, we're not talking about character in this case, but in reality, that is what the appellant is saying. It's a commercial character. The use by the landowner for commerce is one of the reasons why it would not be appropriate to register this land. Could I now ask the court to turn to page 577? In the middle of page 577, there's a subheading, does registration create any rights? And from paragraphs 45 to 53, which my learned friend asked you to read, so I'm not going to ask you to reread them, this issue is addressed. Of course, it's important to bear in mind the context here. The context here was the landowner had done nothing on the land, so there was no issue of pre-existing pre-registration use by the landowner. There was no conflicting use. Now, at paragraph 45, Lord Hoffman says, where he's raising the questions, does registration create rights? He said, if it does create rights or fall within the Victorian statutes, they will not be able, the landowner will not be able to use the land in a way which wholly excludes the local inhabitants from using it for lawful sports or pastimes, whatever. But that's how he phrases the balance between the landowner and the local inhabitants there. Over the page, he puts it slightly differently. That's at paragraph 50, but it then goes on to say that does not mean the owner is wholly excluded from the land. He still has the right to use it in any way which does not interfere with the recreational rights of the inhabitants. There has to be give and take on both sides, Fitch and Fitch. So that he puts it slightly differently at paragraph 51 to how he put it in 45. Paragraphs 54 through to 57, Lord Hoffman deals with the Victorian statutes. Paragraphs 54 and 55, he sets them out. And paragraph 57 is absolutely critical. Court notes there's virtually no authority on the effect of the Victorian legislation. Then says that the aim appears to have been nuisances, which is consistent with what the Court of Appeal said in this case. Lord Hoffman then goes on to say, but I do not think that either act was intended to prevent the owner from using the land consistently with the rights of the inhabitants under the principle discussed in Fitch and Fitch. So that's Lord Hoffman's approach. I quite accept the Supreme Court in Lewis developed that further. We then have the passage about Lang Holmes. After that, it's important to note in relation to Lang Holmes, the focus Lord Hoffman is saying is look at the practice. Are they inconsistent as a matter of fact? And again, that's what the Court of Appeal held in this case. Now, one passage I do want to emphasise, it says, Lord Hoffman says, this is about 2/3 of the way down, nor do I follow how the fact that upon registration, the land would be subject to the 1857 and the 1876 Acts can be relevant to the question of whether there has been requisite user by local inhabitants for up to 20 years before the date of the application. So that is his view of the Victorian statutes. At this point, my lord, I think it might be useful. The next passage, the court says, or Lord Hoffman says, I have similar difficulty with paragraph 141 of the judgment of Judge Howarth in the Humphreys case, in which he decided that acts of grazing and fertilising by the owners would have contravened the Victorian statutes if the village green, if the land had been a village green at the time, and that prevented the land from satisfying the section 22 definition. Can we now turn to the Humphreys case? The recreational use claimed here was pretty sporadic. Yes, Lord Bowes.
So, sorry, I think Lord Stevens may have a question.
I do apologise.
No, just before you move us on from Lord Hoffman, can I just take you back to paragraph 50?
Yes, my lord.
And I think this was in my mind when I asked you a previous question. Because what Lord Hoffman there seems to be saying is, well, once you've registered for some form of sport or recreation, it really doesn't matter thereafter what the form of recreation is, because the recreators are entitled to pursue all those forms of recreation. He doesn't say subject to the rights, pre-existing rights of the landowner. So I read that as inconsistent with your proposition that you've already put forward, that the give and take that we're talking about is that the that the recreators cannot interfere with the pre-existing activities of the landowner.
My lord, I quite appreciate that point. We say paragraph 50 was in part qualified by paragraph 51 and give and take, but that doesn't go as far as what we are saying. The basis of our point here is the Lewis decision, where the court considers paragraph 50 and reaches the conclusion that it does not limit their conclusion. So applying paragraph 50, my lord, we may have some difficulties, but the law developed in Lewis beyond what is said in paragraph 50. And we say, so that's the answer.
Thank you very much.
Lord Stevens.
Yes. If I take you back to paragraph 45 at page 577,
yes, my lord.
You emphasize the words wholly excludes. And I just wanted to test that through, because I thought that you were submitting that both parties, that's the recreators and the landowners, were constrained by the use that they had occurred in the previous 20 years. But those words, wholly exclude, would leave open the possibility of the landowner using the land in some different way, provided it didn't exclude the local inhabitants. And if one took this as an example, this bit of land, you could see that the landowner might be able to build houses on it, provided it didn't wholly exclude the recreators from having various areas available to them for walking dogs and carrying on their pastimes. And so I would just like to know exactly what you're saying. That is, are you relying upon wholly exclude, or are you relying upon constrained by the previous 20 years?
My lord, I apologise. I didn't make this clear. It's entirely my fault. Our case relies very much on the Supreme Court in Lewis. The point I'm making here is Lord Hoffman formulated the balance between the inhabitants' rights and the landowners' rights in three different ways. So I've taken you to the passage in paragraph 45. I'm not saying that is the correct approach. I'm just saying Lord Hoffman formulated it in various different ways, and it's going to come on to explain that it was developed by the Supreme Court in Lewis. So what the way Lord Hoffman puts it in paragraph 45 is different to how he puts it in paragraphs 50 and 51. And it's also different to how he puts it in paragraph 59. We haven't looked at paragraphs 58 and 59, which you'll find on page 580 of the report, but it might be a sensible time to turn to them. Unlike this case, there was a human rights argument being advanced, and it was said there should be a Section 3 Human Rights Act construction because the ordinary meaning interfered with the landowner's convention right. That argument was rejected, not pursued here. But at the end of paragraph 59, Lord Hoffman says, in the present case, first the owner retains his title to the land and his right to use it in any way which does not prevent its use by the inhabitants for recreation. And secondly, the purpose of registration is preserving open spaces. So the point I'm just getting here is Lord Hoffman put it in various different ways. we say that the correct approach is set out in the Supreme Court in Lewis. My learned friend very much relies on the way Lord Hoffman put it in 50 and 51, but that's not the whole picture, my lord. That's the point I was making, albeit very badly, and I do apologise for that. So
I'm not suggesting. Could I just say, Lord Hoffman's paragraph 59 leaves open the question: who decides which recreational activities they can pursue? It's very general indeed.
Yes, my lady, I accept it's very general, and it's different to the way he phrased it, paragraph 50 and 51. So before the questions, we were at paragraph 57 and Humphreys. Does everyone have a copy of Humphreys? Thank you very much. At paragraph 17 of the judgment, the judge said that the Victorian statute make most agricultural activities on a TVG a criminal offence. His interpretation of the offences created by the statutes appears to accord with the appellant in this case. At paragraph 20, the judge cites the Lang case to the effect that recreational use compatible with agricultural uses, which would themselves become criminalised upon registration, cannot be sufficient for the purposes of section 22 of the Commons Registration Act 1965. Again, this is essentially identical to the argument the appellant makes in this case. Paragraph 22, the judge says he will follow Lang. Applicant will have to show that the landowner has not used the land in such a way that would be prohibited by the Victorian statutes post-registration, and that concurrent use is not sufficient. Paragraph 46, judge says that grazing of 20 or so cows would have been an offence under the Victorian statutes. Moving on to paragraph 137, judge concludes that agricultural use during the relevant period consisting of annual spreading of fertiliser, chain harrowing, grazing of cattle and horses, that was the use. The judge found that the recreational use was not sufficient. The following paragraph, paragraph 138. Paragraph 140. Sorry, paragraph 141, which is the paragraph Lord Hoffman refers to specifically and concludes is wrong. The judge there concludes that the agricultural use, i.e. the fertilising and the grazing, would amount to a criminal offence under the Victorian statutes, and that's for the reasons given, i.e. following Lang, this prevents registration under section 22. So what the judge here did was basically accepted all of the appellant's arguments that are being articulated today. Very broad very broad interpretation of the Victorian statutes. It criminalises all this, and therefore that prevents registration following Lang. And Lord Hoffman says, I've had similar difficulty with paragraph 141 of the judgment, in which the court decides grazing and fertilising by the owner would have contravened the Victorian statute if the land had been a village green at the time, preventing the land from satisfying the section 22 definition. That encapsulates the appellant's argument in this case, we say.
Mr. Sharland?
Yes.
Can I just be clear what your proposition is? Are you saying it's of no relevance whether or not there's criminalisation under the Victorian statute to registration? Or are you saying that this Humphreys case is correct in the sense that it is important to know whether there's criminality before one registers, but that the interpretation of the Victorian statute is excessively wide?
The former, my lord. My submissions are consistent with what Lord Hoffman said in paragraph 57. Potential criminalisation is irrelevant to the decision to register. Lord Hoffman says, nor do I follow how the fact that upon registration the land would become subject to the Victorian statutes can be relevant to the question of whether there had been the requisite user by local inhabitants for upwards of 20 years before the date of the application.
But that was on the basis of Fitch and Fitch. You have to read the para as a whole.
My lady, I quite accept that comment is in response to what Mr. Justice Sullivan said in Fitch and Fitch, but the point still stands. He is saying that the Victorian statutes are not relevant to the decision to register.
Sorry, I may be misunderstanding this. There's a distinction between whether or not what would have previously gone on would have amounted to a criminal offence. Isn't that different from whether it will from here on be a criminal offence? Or are you saying there's no difference, that it makes absolutely no, the criminalisation is completely irrelevant to the question of registration?
My lord, that is what we're saying. We're as an alternative argument, if you're against us, we say the pre-registration user isn't criminalised in this case, and the Court of Appeal were right to hold. So we've got alternative arguments. But yes, that is my submission. If you look at the text of Section 15, there is no suggestion that the court needs to, the registration authority or the court needs to consider possible post-registration criminalisation. I'll come to that in more detail when I get to ground 3, my lord.
So, Lord Justice Lewison's careful attempts to explain why there wouldn't be criminalisation in this case, his interpretation of the Victorian statute, you say, is just completely irrelevant. Unless we're against you, unless we go on to the second limb of your argument. But on the first limb, that was an unnecessary exercise.
Yes, for the appellant to succeed, they have to succeed on the first 2 grounds. One, that post-registration criminalisation is relevant to the issue of whether to register. And also, in this case, pre-registration use would be criminalised. Because if it's not criminalised, it really doesn't matter. So the appellant has to establish both to succeed. We say he fails on both, but there are alternative arguments.
Sorry, but Lord Justice Lewison clearly thought it was important for him to decide whether there was criminalisation in order to decide whether there should be registration, didn't he?
No, my lord. I would say that both Mr. Justice Barling and Lord Justice Lewison we're looking at these in the alternative. There are 2 separate points.
Well, thank you.
Yes, Mr. Charlotte. How does a registration system work in circumstances where a landowner is permitted to carry on the activities he had previously carried on, if those activities are then criminalised? Why does a court permit there to be registration? Why does Parliament intend there to be registration in such circumstances? You say the landowner is permitted to do exactly what he had been doing before. If that becomes criminal, why should any legal system then permit registration if that then makes a criminal out of the landowner?
Well, I would go back to the clear text of Section 15 and what it says the registration authority has to address its mind to.
But if I could interrupt, why do we interpret Section 15 without looking at the broad scope of the other statutory regimes? Are you contending that Parliament intended to criminalise behaviour which it was going to permit?
No, my lord, I'm not, and that goes to our argument on the interpretation of the Victorian statutes. We say
that's a separate point. but I wanted to clear the decks, as it were, in relation to the first point. Are you maintaining the position, and it's perfectly open to you to do so, that even if this is criminal, registration should still take place?
Yes, my lord.
Yeah, okay.
My lord, I've been taking you to Lord Hoffman. I don't think there's anything further I need in Lord Hoffman's judgment, but I did want to take you to a couple of paragraphs in Lord Scott's judgment, which you'll find at paragraphs 98 and 99, which is page 595. Lord Scott dissented on the character issue and various other issues. However, he did agree with Lord Hoffman on the relevance of the Victorian statutes, and that's set out at paragraph 98 to 99. If I could ask the court to read that to himself. So, my lord, we essentially say that both Lord Hoffman and Lord Scott were saying, in response to Lord Stephen's question, no, that isn't relevant.
And Mr. Charlton, can you just help me? I know I should have read this more carefully. What did the other law lords decide in this case? What was the pattern of agreement and disagreement?
The pattern of agreement, Lord Walker and Lord Roger agreed with Lord Hoffman, and Lady Hale basically said that we shouldn't be considering these issues because it's an academic exercise, so she didn't express a view. So Lord Hoffman's views commanded majority support. In relation to this particular point, and the only point where it does command, 4 judges agreed with what Lord Hoffman said about the Victorian statutes not being relevant to the issue of registration.
Right, thank you.
Thank you very much, my lord. Now, I accept that these observations from Lord Hoffman and Lord Scott on the relevance of Victorian statutes to the decision to register were strictly obiter, but they're not mere judicial musings. There was an issue as to whether Oxford City Council, as responsible registration authority, was entitled to ask the court to rule on the applicability of the Victorian statutes if they were not relevant to its task of determining whether to register the land as a TVG. The Judicial Committee therefore had to consider the extent to which matters which become live only after registration nevertheless affect the issue of registration itself. Of those members of the Judicial Committee who expressed an opinion on this point, all agreed that the legal position post-registration, including the rights and obligations to which registration gives rise, was of no relevance to the City Council's task in determining whether to register the land as a TVG. If Parliament had taken a different view on the relevance of Victorian statutes to the decision to register, it could, of course, amended the definition of TVGs when it enacted the Commons Act 2006 to make this clear. It did not do so. My lady, it might be a suitable place to pause. I'm now going to turn to Lewis, and there's going to be some more lengthy submissions on Lewis. So I suggest, I'm obviously in your hands, a 5-minute break now.
No, I think that's a good idea. But what I wanted to ask you was just how you're doing on time, because we've been asking you a lot of questions, and I want to be sure that we haven't prejudiced your concluding in time. I don't know what time you're handing over actually to counsel.
I'm looking to hand over about 2:30. And I will endeavour. I think if I run 5 or 10 minutes over, Mr. World won't shout at me too loudly. But I'm definitely going to have to pick up the pace, it's fair to say.
Okay, we'll bear that in mind in our questions, but it is important that we ask you the ones that go to the heart of it.
Of course, my lady, of course.
We're ready to resume. Thank you very much, Mr. Charland.
Thank you very much, my lady. So turning now to Lewis, which you'll find at page 609 of the electronic bundle. Like Oxfordshire, the appellant accepts that this case was correctly decided and is not per incuriam. Just want to briefly touch on the facts. Lewis concerned land which during some of the 20-year period had been used landowner for golf and local inhabitants mainly for walking with or without dogs. Those two uses coexisted broadly harmoniously. There was an exception, squadron leader Kime, referred to in Lord Walker's judgment, took great objection to it, but other than that, it was broadly harmonious. Local inhabitants deferred to the landowner's use, i.e. the golf. Supreme Court concluded that notwithstanding this deference, the local inhabitants' use was as of right. We say the present case is on all fours with Lewis. The two uses here have coexisted harmoniously for well in excess of 20 years, indeed more harmoniously than in Lewis. There was no equivalent to squadron leader Kime. Before we look at the detail of the judgment in Lewis, can I just remind you of Mr. Justice Barling's findings of fact on this, which you'll find at page 285 of the bundle. Paragraphs 159 and 160 deal with an argument advanced by the appellant that this case could be factually distinguished from Lewis. And Mr. Justice Barling rejected that argument. He found on the facts that the striking parallels between the two cases, just as pedestrians sensibly give way to vehicles on the quay, so it's highly unlikely that it was merely politeness that caused ramblers to wait until golfers had passed before entering the playing area. A driven golf ball, like a commercial vehicle, presents a danger to persons in its path and is going at a far higher velocity and more unpredictably than the slow-moving vehicles on Allen's Quay. So the court, on the facts, concluded that they were on all fours, striking similarity. Now, my written submissions on Lewis are at paragraphs 28 to 43 of the written case, which is at page 134 to 139. We say there are three elements to the ratio of the Supreme Court in Lewis. Firstly, so these are the propositions we get from this case. Firstly, the local inhabitants' recreational use can be as a right when such inhabitants have deferred to use by the landowner if, as a matter of fact, such uses peacefully coexisted during the relevant 20-year period. That's the first proposition. I don't believe that is controversial. Second proposition, which we say is part of the ratio, to determine whether or not land should be registered as a TVG, the registration authority merely has to consider the matters set out in section 15, i.e. have a significant number of inhabitants of any locality or of any neighbourhood within a locality, have they indulged as a right in lawful sports and pastimes on the land for a period of at least 20 years, as a right limited to the tripartite test. There is no additional question to be asked concerning quality of user or indeed anything else. Third proposition we take from Lewis is, although sports and pastimes in section 15 denotes a single composite class and land registered as a TVG can be used generally for sports and pastimes, registration neither enlarged the inhabitants' rights nor diminished those of the landowner who retains the right to use the land as he has done so before. So those are the propositions. First one I don't think is controversial. The second and third are essentially taken from the head note. More importantly, the third proposition reflects the court summary of Lewis in the Lancashire case at paragraph 8, which I took you to earlier. Turning to the judgment, can we begin with Lord Brown's judgment at paragraph 98? He most fully addresses the issue of post-registration rights. Paragraph 98 he formulates the question differently to facts and issues. He says the critical question to my mind is what are the respective rights of the landowner, brackets the owner, and the local inhabitants, brackets the locals, over land once it is registered as a town or village green. That then discusses the facts, and the critical paragraphs are 100 through to 101, where he sets out his analysis and his views. At the top of page 644, however, as I prefer to conclude, the effect of registration is either to entrench the previously assumed rights of the locals, precluding the owner from thereafter diminishing or eliminating such rights, but not at the expense of the owner's own continuing entitlement to use the land as he has been doing, then I would hold that no more is needed to justify registration than what by common consent is agreed to have been established by the locals in the present case. Paragraph 101 explains the reasons for this conclusion. It's not merely because, in my opinion, no other approach would meet the merits of the case. By this he means, we say, that where you have two coexisting uses that have existed harmoniously for 20 years, that leads to this conclusion. And of course, that is equally applicable to the present case. He then goes on to say, also, it is because, to my mind, on the proper construction of section 15, the only consequence of registration of land as a green is that the locals gain the legal right to continue to indulge in lawful sports and pastimes, which previously they had merely done so as of right, no more and no less. The extent of the owner's own previous use of the land prevented their indulgence in such activities in the past. They remain restricted in their future use of the land. And we say that analysis applies equally to this case. There was some suggestion in the judgment of Lords Carnworth and Lord Sales in Lancashire that perhaps Lewis is just dealing with the golf situation. But if you look at the basis for Lord Brown's conclusions, it's not focusing on the particular facts, it's broad analysis of the particular text of section 15. Then goes on to say in paragraph 101, of course, insofar as future use by the locals would not be incompatible with the owner continuing in his previous use of the land, the locals can change or indeed increase their use of the land. They're not confined to the same lawful sports and pastimes, the same recreational use as they had previously enjoyed, but they cannot disturb the owner so long as he wishes only to continue in his own use of the land. So in Lady Arden's example of the badminton, that would not be permissible because it would disturb the landowner's use. Paragraph 102 through to 104, Lord Brown considers Lord Hoffman in the Oxfordshire case, and particularly paragraphs 50 and 51, and says, is what the court said in that case a problem for us? Paragraph 104, he said, I repeat, the position arising on registration at a time when both the owner and the locals are using land is in theoretically conflicting ways, but in fact harmoniously simply did not arise in the Oxfordshire case. And for my part, I would decline to treat that case as if it decided how such an issue would be resolved. So clear consideration of the passage in Oxfordshire that Lord Burrows pointed out to me, but concluding that it did not prevent the conclusion that Lord Brown wanted to reach. Turning over to Lord Brown's conclusion, this being so, i.e. his analysis of post-registration rights, he says, if the court could just read paragraph 107 to itself, it's a no additional question point. So that's Lord Brown's speech. On the same page, we have Lord Kerr's speech. Paragraph 109, he agrees with Lord Brown. And we say the critical part of Lord Kerr's speech is paragraphs 114 to 115. And if I could ask the court to look at that. Lord Kerr makes it clear that he agrees with Lord Brown, and whatever Lord Hoffman said in Oxfordshire, it is now clear that where it is feasible, cooperative, mutually respecting uses will endure after the registration of the Green. Where the lands have been used by both the inhabitants and the owner over the pre-registration period, the breadth of the historical use will be not exactly equivalent to, at least approximate, that which will accrue after registration. Could I now ask the court to look at Lord Hope's judgment? And Lord Hope agrees with Lord Brown's analysis. Paragraph 54 of his judgment, which is at page 631, Lord Hope says, I agree with Lord Brown that the critical question, which none of the issues addresses, is what are the respective rights of the local inhabitants and the owner of the land once it has been registered. At paragraph 78, he agrees with all the other judgments, including those of Lord Brown and Lord Kerr, which I've taken you to. Paragraph 55, the last sentence, he talks about, one must assume that Parliament's intention that practical common sense would be a guide to the best way the public right was exercised once the land had been registered. At paragraphs 75 to 76, Lord Hope, 74 through to 76, Lord Hope considers what Lord Hoffman said in Oxfordshire to see whether that is inconsistent with what Lord Brown held and what he wants to hold. And he concludes that rejecting what Lord Hoffman said, or at least clarifying it, that does not prevent the court in this question, in this case, from reaching the conclusion it did reach. Paragraph 76, Lord Hope acknowledges, of course, the position may be that the two uses cannot sensibly coexist at all. Of course, that is not the case here, because as a matter of fact, they can coexist without any difficulties.
Mr. Charland?
Yes, my lady.
There's a lot of concentration here on what the position would be afterwards. It isn't in terms of the criminal position, but it's a lot of concentration on what the position would be afterwards, as going to the question of whether it should be registered or not. We've seen it in a number of different guises. So why is that different from the question which they don't consider specifically, which is potential criminalisation of the landowner's activities?
Well, I think the focus of whilst I quite accept there's discussion of pre-registration rights, the factual focus when considering Section 15 is what occurred before was the use as of right. And the question was, because the local inhabitants deferred to the golfers, did that render it not as of right? And the court concluded that didn't render it not as of right, it was as of right. So the conclusion was, looking at the pre-registration use, looking at the elements of Section 15, should there be registration? Now, the court also goes on to consider the consequences of registration, but the focus is still on the elements of section 15. And I was going to take you to some passages in Lord Hope's decision where that is made clear. Yes, Lord Burrows.
Can I just follow on from that question? And it may be, again, an ignorant question on my behalf, but what I'm anxious to be clear about is what is the effect of registration? If one rules out any criminal aspects to this, what are we actually talking about in terms of these conflicts of rights? Are we talking about private law enforcement through the law of tort? Is that what we're talking about?
Yeah, well, my lord, firstly, on ruling out criminal, we're ruling out criminal if the landowner's use is merely its pre-registration use. But if the landowner decided to use the land for something completely different that was inconsistent with the local inhabitants' rights to recreate, you may be in the criminal context.
Right.
That's the first point. But yes, in relation to enforcement, it would be an application by a local inhabitant, I think, seeking an injunction. It would be equitable relief.
Based on what cause of action?
Well, it would be asserted that it interfered with their rights to recreate, to use the land for lawful sports and pastimes.
And that's what? That's the tort of private nuisance, is it? Or tort of public nuisance?
I'll have a think about that, my lord.
Right, but if I just put it the other way around.
Yes, my lord.
If the recreators infringed, let's just say they stood in the way of lorries coming through the TVG, what's the cause of action of the landowner in that position?
Well, I would have thought it would be the same cause of action whether there was or was not a TVG. The existence of a TVG does not form the basis of that right. The landowner has a right to use his land and drive over the HGV, and if that's interfered with, one could seek relief from the courts. As to the precise legal claim that would be...
Well, might I suggest to you that is probably the tort of private nuisance?
It may well be, my lord, yes.
Yeah.
Definitely.
So, I mean, presumably we're talking about normal ways in which landowners' rights are protected. But I'm just anxious to be clear in my own mind what the effect of registration is to that position. And I would have thought that looking at it the other way around, what you're giving by registration is at least rights that are protected by law through the tort of public nuisance. And then my question will be, well, if that's the case, isn't that inevitably bringing in the crime of public nuisance? That would be my question. I need to know what you're doing with registration in relation to the recreator's rights.
Well, I think both the tort and the criminal offence would cover the same ground. There would be no basis of criminal prosecution or a private law claim if the landowner was merely using the land for its pre-registration uses, because that is lawful. So that would prevent either private law or criminal law claim being brought. If, however, the landowner decided to use the land for something completely different, and that did interfere with the local inhabitants' rights, you could have criminal sanction and you could have a private law claim brought.
Thank you.
Lord Sales.
Yeah, sorry, it was really to seek to make a contribution in relation to what the rights of the parties would be if there is registration. From the point of view of the recreators, as it seems to me at the moment, they acquire, in effect, rights equivalent to an easement. They're not easement rights, they're common rights they sort of fall between easements and common rights as they existed at common law, but they are a statutory creation. And they could enforce those rights in the way that one would enforce an easement or rights of common, which are property rights or with certain characteristics. And so, Mr. Charland, I think you were right that typically the relief would be but injunctive by reference to those underlying property rights. Turning to look at the landowner's position, typically I think the landowner, if his proper use of the TGV was being blocked by the recreators, would have a claim in trespass. I mean, they may have claims in other forms of tort as well, nuisance. But if one goes back to Fitch and Fitch, what was being said there was that there was trespass, the tort of trespass being committed. What was relied upon were the rights of common as an answer to the tort of trespass, and of course it failed in that case. But conceptually, I would have thought that the landowner would simply assert his landowner rights, which usually you do relying on the tort of trespass, and then it would be up to the recreators to try to establish a defence if they had one. So it's really an observation following on from Lord Burrows, but if you've got a comment, please make it.
I would very happily agree with that. I see Lord Stevens has a question, which may be to me or to you.
I would only add to that the landowner relying upon trespass against a particular individual might have an obligation to bring in either the Attorney General, by analogy with a public right of way, or the county council who registered the land. And the public were involved in the litigation.
Yeah, if I might observe, I think that sounds right, because in a sense, it's not purely private rights which would be being asserted here. They would be an individual seeking to rely on rights which were had a public character, as my lord has pointed out.
Very nice, Mr. Charland, when we answer the questions rather than
Far better than I managed, my lady. Far more learned. If we could return to Lord Hope's judgment in the Lewis case, paragraph 53, he sets out the issues as articulated by the parties. And this is page 630, my lords and my lady. And it said the first issue was where land has been extensively used for lawful sports and pastimes, nec vi, nec clam, nec precario for 20 years by the local inhabitants, is it necessary under section 15.4, the 2006 Act, to ask the further question whether it would have appeared to the reasonable landowner that users were asserting a right to use the land for lawful sports and pastimes in which they were indulging? So that was the first issue as articulated by the parties. As we've already looked at, their lordships formulated the issues differently, but Lord Hope does answer this particular question. At paragraph 67. So before I turn to that, can I just turn to page 632? There was a passage here that I didn't highlight and wanted to. The end of paragraph 59, right at the bottom of 632, Lord Hope says, in the context of Lord Hoffman's judgment in Oxfordshire, do not think that what Lord Hoffman said in paragraph 51 could be elevated to a ruling on the point which on the facts did not arise. So again, distinguishing Lord Hoffman because there's a very different factual basis in Oxfordshire. Paragraph 64 onwards, Lord Hope addresses the issue of the section 15 questions. That's page 634. And the critical paragraph I rely on is paragraph 67, my lords and my ladies. And we say this is essentially a complete answer to ground 3. After setting out questions about section 15.4, Lord Hope says, in the light of that description, it is, I think, possible to analyse the structure of section 15.4 in this way. The first question to be addressed is the quality of user during the 20-year period. It must have been by a significant number of inhabitants. They must have indulged in lawful sports and pastimes, where lawful indicates that they must not be such as will be likely to cause injury or damage to the owner's property. And they must have been doing so as of right. So that is what Lord Hope is talking about when he talks about the quality of user. It's a reference to the language of the relevant provision in section 15. He then goes on to say, and they must do so as a right, that is to say openly, in the manner the person rightfully entitled would have used it. The user for at least 20 years was of such amount and in such manner as would be reasonably regarded as being an assertion of public right. The owner will be taken to have acquiesced in it unless he can claim that one of the three vitiating circumstances applied in his case. If he does, the second question is whether the claim can be made out. In relation to the first question and the second question, Court of Appeal have determined that both of those in our favour, and there's no appeal. Once the second question is out of the way, either because it's not been asked or because it has been answered against the owner, that is the end of the matter. There is no third question. So the answer to the first issue is no. And the first issue is the issue referred to at paragraph 53. Should an additional question be asked, a further question, whether it would have appeared to a reasonable landowner that users were asserting a right to use the land for lawful sports and pastimes in which they were indulging. Paragraphs 68, 69 develop that point. I think that's all I wanted to say about Lewis, given the time. Now I'm going to turn to ground one. Obviously, a lot of my submissions have been related to ground one. I addressed this at paragraph 49. Yes, my lord.
Yeah, I'm so sorry. It's just the keeping the score on the who is agreeing with who in Lewis. If you would just assist us with that.
That is actually quite a complicated question because judges often agreed with all the other judgments.
All right. Well, tell us what your submission is in terms of agreement, and then we can decide whether you're right or not.
Certainly. Well, I say in relation to the post-registration rights, Lord Brown, Lord Carr, and Lord Hope form the majority on that point. I wouldn't say that Lord Roger and Lord Walker dissent on that issue, but they definitely put it slightly differently. And in reality, we say the appellant accepts that analysis. If you turn to paragraph 43 of their written case, which is page 98 of the bundle, you'll see at page 98, the appellant accepts if has been held by the majority of this court in Redcar, the rights of the locals in respect to the TVG are in practice constrained forever by the nature of use which was made by the owner of that land during the relevant 20-year period recreational use. So it's accepting that the majority, i.e. Lords Brown, Lords Hope and Lord Kerr, did conclude that. In relation to the quality of user point, we say that there's broad consensus. I think Lord Hope analyses it in most detail, but Lord Walker at paragraph 20 says, essentially makes the same point. That's page 621. Lord Brown at paragraph 107, which is 646, and Lord Kerr at 116, which is at page 648.
And Lord Roger, did he just not deal with that?
I believe he did, but I don't have a reference for it. I will dig out over the short adjournment the Lord Roger reference.
All right.
Thank you very much. My lords, could I now ask you to turn to my statement, my written case, at page 141. Paragraph 49, we agree with the appellant's analysis that the question for the court is one of statutory construction. And over the page at 142, we set out the statutory construction that the appellant is essentially arguing for. The appellant is saying that these words should be essentially read in section 15. Clearly, that's a construction that departs very significantly from the ordinary principles of statutory construction, not an interpretation which one would discover from reading the words, or indeed any part of the Commons Act 2006, contrary to the clear language of the provision, and we say it's contrary to the purpose of the provision. As I mentioned in my introductory remarks, this is not a case where the appellant contends that the ordinary construction interferes with a convention right, such as the right to property. Thus, there's no scope for application for Section 3 Human Rights Act, permitting a far more strained interpretation of the statutory provision. Now, at least in its written case, the basis of the appellant's argument as to why these words should be read in is statutory incompatibility. The argument advanced is we are in the same sort of territory as the Supreme Court was in New Haven and in Lancashire. That is the argument that is being advanced. And we say, no, we're not. We're in a completely different situation. Bear in mind, this is a privately owned port, not held for any statutory purposes. So unlike New Haven, you don't have statutory incompatibility. The statutory regime in New Haven obliged the port to maintain and continue running the port, but there is no such obligation here. Paragraph 53, I set out a quote from the Lancashire case summarising what the majority held in New Haven, an incompatibility between the general statutory powers under which land is held by a statutory undertaker and the use of such land as a town and village green excludes the operation of the 2006. The ratio of both New Haven and Lancashire do not apply here, where the appellant is not a public authority or a statutory undertaker pursuing statutory powers, but a private organisation that has no statutory obligations as a port operator. We say more fundamentally, the principle recognised in these cases has no application where, prior to registration, and so prior to any question as to the application of the Commons Act 2006 ever arising, ownership of the land is not governed by a statutory scheme that Section 15 is said to be incompatible with. The Victorian statutes simply don't apply at that stage. In such circumstances, there's simply nothing upon which the principle of statutory incompatibility can buy. Furthermore, it's clear from the majority judgments of Lord Colmworth and Lord Sales in Lancashire that particular considerations of public interest were at play in that case. They emphasised the public interest reflected in the specific statutory provisions under which the publicly owned land is held. Their lordship said it would be surprising if use of land which Parliament intended to be held for good public purposes, defined in statute, was stymied by the application of the 2006 Act. Accordingly, in such cases, the general public interest reflected in the Commons Act was outweighed by the specific public interest on the specific statutory regime. These considerations, of course, do not apply in the present case. There's no pre-registration statutory scheme whose operation must be compatible with the registration provisions of the 2006 Act. As such, there's no freestanding statutorily recognised public interest which may be harmed by registration. There's simply no statutory incompatibility to resolve. We say that the correct approach is set out in the partially dissenting judgment of Lady Arden in the Lancashire case at paragraph 78, which is 677 of the bundle. So paragraph 78, Lady Arden sets out what she understands to be the correct approach, considering the statute as a coherent whole. We don't understand this to be part of the dissent. We say, applying this approach, there is no statutory incompatibility regardless of whether continuation of pre-existing use is criminalised. Both provisions can be given full effect, section 15 when considering whether or not to register, and the Victorian statutes when considering whether or not any post-registration use is criminal. Accordingly, the question is whether the requirements of section 15 alone, properly construed, have been met. We say in such circumstances the Court of Appeal was correct to reject the appellant's argument based on the New Haven case. We say the appellant's argument on statutory incompatibility is also inconsistent with the Supreme Court's judgment in the Lewis case. And now paragraph 62 of the written case.
Sorry, Mr. Shalland.
Yes, I do apologise.
No, just taking you back to that proposition that both provisions can be given full effect. I just wonder how you give full effect to permitted use by a landowner if you criminalise it.
My lord, I think you are giving full effect to both provisions. I appreciate the tension. Of course, we contend that it's not criminalised, but that's a separate point. I accept that. But you are giving full effect to section 15 by applying the words in the statute, and you're giving full effect to the Victorian statutes by applying those. Whilst there may be a tension potentially, albeit we say there is not, we say you are giving full effect there.
But it's not very attractive for the landowner. You're giving him the right, you say, to carry on as before, but it's going to be criminal.
My lady, I hear what you're saying. Yes, I hear what you're saying there, my lady.
Could I just also, just to pursue that, take you to 732 paragraph 95 in New Haven, where the majority judgment says the registration of the beach as a town or village would make it a criminal offence to damage the green or interrupt its use and enjoyment as a place for exercise and recreation, section 12 of the Enclosure Act, or to encroach or interfere with the green, section 19 of the 1876 Act.
Yes,
they were taking the view, irrespective of incompatibility, that there was going to be a criminal offence.
My lady, I accept that. I don't think the judgment in Lewis was considered on that point. This is an obiter comment because it wasn't critical to the decision. And I would note that Lord Carnworth adopts a different view or tentatively suggests a different approach at paragraph 139.
But that was a dissenting judgment. This is the majority's judgment, and I don't think the conclusion could be said to be obiter. Part of the reasoning.
Well, I don't think Lord Carnworth was dissenting. I think he was concurring.
All right.
But I don't accept that paragraph 95 is part of the ratio in this case. Indeed, the claim failed before you even got to the statutory incompatibility argument. The court went on to determine the statutory incompatibility argument, but the claim would have failed even if the court had not addressed its mind to the statutory incompatibility argument at all. So I don't accept that paragraph 95 is part of the ratio, my lady.
Thank you.
My lady, my lord, if my learned friend's analysis of the Victorian statutes is correct, and they are as broad as he suggests, and he sets his analysis out at page 113 to 115 of the bundle. He says it criminalises any activity that somehow interferes with the soil or does any act that does injury to the TVG. This would criminalise the swinging of a golf club which contacts the green as well, or instead of the ball, and results in a small digging up of the grass. Similarly, the digging of a bunker and the placing of sand in the bunker would both be criminal acts on the appellant's broad interpretation. When my learned friend was asked about this yesterday, he suggested that the Victorian statutes would perhaps not apply to recreational uses. Well, if you look at the terms of the Victorian statutes, there's of course no exception for recreational uses. Firstly, a golf club can be a commercial activity in the same way as a port can, but the Victorian statutes do not draw any distinction between recreational or golfing use and commercial use. Applying the appellant's interpretation, they would criminalise both uses. Indeed, the logical result of the appellant's argument would be that it would not be possible to have coexisting uses of the landowner's post-registration, and the landowner's post-registration use would inevitably be criminalised. Golf in Lewis, agricultural use in Lang, they would both be criminalised. The only way this result can be achieved is by overruling Lewis, and the appellant has made it clear that he is not asking for the court to do that. Now going to turn to the issue of the health and safety regime. In contrast to its position under the Victorian statutes, the appellant does not say that the continuing use of land would be criminalised under this regime as a result of registration. This is not surprising given the absence of any suggestion of prosecution for the 20 years prior to registration or the 6 years since registration. We say this is fatal to this aspect of the appeal. The issue for the court to determine on ground one is whether land can be registered as a TVG if the effect of registration would be to criminalise it. You can see that from pages 75 and 76 of the bundle. The page 75, issue 1 as drafted by the appellant, can land be registered as a town or village green if the effect of registration would be to criminalise the landowner's continuing use, so use of the word would. On the appellant's case, there is thus no current statutory incompatibility. As far as the council understands the position, the appellant contends that the mere possibility, however remote, of a prosecution at some point in the future, which may possibly result from the introduction of new legislation, is sufficient, and in those circumstances, the land should not be registered. And at paragraph 63, I set out the wording that, this is page 146 of the bundle. That is the wording that the appellant is proposing should be read into section 15 in relation to its health and safety argument. We say there's absolutely no basis for reading in those words. for the reasons I've expressed. There's no issue of statutory incompatibility. And I would make the factual point that I flagged up from the outset. The appellant has granted the residents of the Maltings a right-of-way, including a pedestrian right-of-way, over the land registered as a TVG. In such circumstances, whether or not the land is registered, there will inevitably be interaction between pedestrians and commercial traffic. Therefore, the registration of the land would not materially affect the risk of prosecution. No doubt the appellant granted residents of the Maltings such a right of way across this land and the more dangerous eastern transit because he had no concerns about the dual use and any risk of prosecution under the health and safety provisions. This is not
but the
surprising.
pedestrians may be required to walk around the outside of the quay as a matter of law.
Pardon, my lady?
The pedestrians may be required to walk around the edges of the quay in order to make reasonable use of the right of way. We don't know anything about the right of way.
No, we don't know anything about the right of way, albeit we do know it's across the eastern transit where the landowner has made very clear this is a dangerous area and you need to be very careful.
Indeed.
So
we have to walk right by the wall. Yep.
Yeah, so we do know that at least. Further, the health and safety duties relied upon are clearly not absolute, and they will take into account the existence of the local inhabitants' rights arising from registration. If we look at the first such provision, which is at page 549 of the bundle, section 3.1 says, this is the provision relied upon by my learned friend, it shall be the duty of every employer to conduct his undertaking in such a way as to ensure, so far as reasonably practicable, that persons not in his employment who may be affected thereby are not thereby exposed to risk to their health and safety. So that requires the court to consider the factual circumstances of the case, including the existence of any such right. Similarly, in relation to the second provision relied upon from the 1992 regulations, you'll find that at page 552 of the bundle. And I think, so subparagraph 1 says every workplace should be organised in such a way that pedestrians and vehicles can circulate in a safe manner. Subparagraph 3C, I believe, is relied upon. Where vehicles and pedestrians use the same traffic route, there is sufficient separation between them. Well, the local inhabitants and the vehicles in question don't use the same traffic route. The TGV route is the route east to west through the Eastern Transit. The local inhabitants can't go across the Eastern Transit and they don't use that route. Of course, the residents of the Maltings use the same route as the vehicles. So there may be an issue of health and safety in relation to those, but not in relation to the local inhabitants. And subparagraph 5 makes clear that subparagraph 2 should apply so far as is reasonably practicable to a workplace which is not a new workplace. So again, reasonably practical, looking at the broader factual circumstance. Yes, Stevens.
Just correct me if I'm wrong, but I thought that Regulation 17 was a duty owed to employees rather than to the public generally. So wouldn't necessarily apply to the recreators in this case. There would be an obligation, of course, under the Occupiers Liability Act, so it may make very little difference. But as far as the criminal law was concerned, I was just concerned that we would just jump into the conclusion that this actually did apply to people other than employees.
My lord, I don't know the answer to that. It may be that my learning from Mr. Holland is best placed to deal with that, given he's relying on that. I can't tell you at this stage. We say even if it does apply to local inhabitants, it doesn't create any real problems. If my learned friend's assertion that Regulation 17 does apply and there must be separation between pedestrians and vehicles, we say the inevitable consequence, given the pedestrian right-of-way granted over the Eastern Transit, is that the port will need to cease operating. But that's nothing to do with the village green. That's in relation to the right-of-way granted. That was all I wanted to say on ground one, my lords and my ladies. Can we now turn to ground two?
Mr. Sharp, sorry. Yes, very quickly, just before we leave ground one, can you tell us where the Court of Appeal deal with this? Because as has been pointed out, they devote quite a lot of their, Lord Justice Lewison devotes quite a lot of his judgment to interpretation of the Victorian statutes at ground two. But where does he accept that even if there were criminalisation, that would not be an impediment to registration?
My lord, can I get you the details of that over the short adjournment?
All right, yes, certainly.
Thank you very much.
Mr. Solon, just before you move on, a difficulty I've got with the way you're approaching this ground one is, my understanding is these are the Victorian statutes, criminal statutes specifically related to town and village greens or areas of common land. So they are specific crimes related to those areas. Now, in relation to that, it would, on the face of it, do you not think, seem irrational to ignore specific crimes related to town and village greens in deciding whether there is a town and village green?
Well, I'm not suggesting that the construction of the two provisions should ignore the existence of the other provision. Our broad point is that the Victorian statutes should be construed in light of Section 15. My learned friend is saying you should construe Section 15 in light of the Victorian statute, but we say that's the tail wagging the dog.
No, but you're saying when we're deciding on whether there's a TVG, it's of absolute no relevance what the criminal position is under those specific criminal statutes.
I'm adopting the position of Lord Hoffman, Lord Scott, Lord Walker, and Lord Roger in Oxford here to that effect.
I think what I'm asking you is whether that's a rational way to proceed.
Well, I'm not sure I can assist any further. We obviously have an alternative argument in relation to the construction of the Victorian statutes. We say the approach of Lord Hoffman and Lord Scott is rational if one looks at the language, but I'm not sure I can take this matter any further.
Thank you.
Very grateful, my lord. Turning to ground two then, which is obviously on similar territory. On the ground two, on the correct construction of the Victorian statutes, would the appellant's activities post-registration be criminalised? My oral submissions on this ground are going to be split into 5 sections. Firstly, the factual starting point and what pre-registration uses are alleged to be criminal. Secondly, past consideration of the Victorian statutes by the courts. Thirdly, some general submissions on the approach to be taken to construing these two provisions. Briefly address the specific language of the two provisions And fifthly, respond to the appellant's suggestion that the Court of Appeal's interpretation creates uncertainty, is unfair to the owner, and undermines the statutory scheme. So that's my broad structure. So the factual starting point, could I ask the court to turn to page 288, paragraph 176 of Mr. Justice Barling's judgment? Here, the court sets out the factual findings before which the Victorian statutes need to be applied. Now, in the appellant's written case, there is no reference whatsoever to the pre-registration use the appellant contends has been criminalised upon registration. Similarly, at no point during oral submissions was the appellant's case clearly set out on this. The appellant is essentially asking the court to determine the question in the abstract. This, we say, is not appropriate. You need to consider what, if any, particular continuing use should be criminalised. And in the Court of Appeal, the appellant, for example, relied on the storage of pallets and said, well, that would be criminalised. And the court addressed its mind to that particular factual assertion and concluded it wouldn't be, analysing the statutory provisions and the evidence. But at the moment, the court is in no position to analyse the question of criminalisation because the appellant has not identified clearly what pre-registration use it says is criminal. We say the absence of such identification perhaps suggests that there is no such use. That's the first aspect of my submissions on ground 2. The second is past consideration of these two statutes. Other than the judgments in this case, the meaning of the Victorian statutes has been considered only briefly in the case law. I've taken you to Lord Hoffman and Lord Scott in Oxfordshire. I don't plan to return to that. A similar view to that of Lord Hoffman in Oxfordshire was taken by Lord Justice Brown in the case of Massey and Bolden, which I don't think we need to turn up, but if I just give you the reference, the case starts at page 1216 and the relevant paragraph is 31, which you'll find at page 1244. This case was relied upon by the Court of Appeal in this case, paragraph 79, and essentially what Lord Justice Brown said adopted the same approach as Lord Hoffman. That was in the context of driving over a village green, and Lord Justice Brown concluded that that would not be criminal. So we say it is analogous to at least some of the use, the HGVs going over it. In relation to Lewis, the appellant argues that the decision of the court should be treated with caution because the court did not refer to the Victorian statute. We accept that the Victorian statutes were not directly an issue in Lewis, albeit they had been relied upon below, and it's quite clear the Supreme Court were well aware of their existence and their effect. There is reference to the inspector's decision, which in Lord Walker's judgment. Could I ask you to turn to page 618 of the bundle, my lords? On page 618, paragraph 12, Lord Walker quotes from Mr. Chapman's report, makes reference to the Victorian provisions and reaches a conclusion as to criminalisation. As Lord Justice Lewison in this case observed, contrary to the conclusion of the inspector, the court in Lewis held both that the land was a TVG and that the landowner was entitled to carry on its pre-registration use, i.e. golf. In so holding, the court implicitly disagreed with the view of the inspector in the case as to the effect of the Victorian statute. Moreover, as I've already explained, if the appellant is correct as to the statutory interpretation, the correct interpretation of the Victorian statutes, Lewis must be wrongly decided because golfing use would be criminalised. My lords and my lady, we say it's important to note that none of these cases on the Victorian statutes have actually considered criminal prosecution. There is no evidence in the law reports of any such criminal prosecution that we could find. Turning to the third aspect of my submissions on the Victorian statutes, general submissions on the approach to be adopted to construction. Firstly, as a matter of principle, Victorian statutes being criminal should be interpreted restrictively as long as that does not cut across Parliament's clear intention. There's a clear, long-established principle against doubtful penalisation, and I refer to the relevant authority or one of the relevant authorities at paragraph 70 of my written case, that's page 149. We say the appellant's approach to the construction runs clearly contrary to that principle. It's an incredibly expansive approach of criminal legislation enacted over a century and a half ago. This is despite being available a reasonable construction of those provisions which interprets their scope more restrictively. Secondly, we say the general purpose of both of the Victorian statutes is to protect TVGs from public nuisances. That's what the Court of Appeal in this case concluded, and similarly Lord Hoffman expressed a similar view in the Oxfordshire case. That is the mischief which both provisions are concerned. The preamble to section 12 of the 1857 Act makes that plain.
Isn't it rather more than that? It's to create a summary offence, a specific summary offence which could be used.
Yes, my lady, we say the matters referred to in these provisions may or may not have been a public nuisance, but because they're set out in this offence, it makes clear that they are public nuisances and that can be summarily prosecuted.
Well, it's a new specific offence, and section 29 contains a deeming provision, yes, but section 12 does not.
It doesn't contain a deeming provision, but if we look at the text of let me the text of the Enclosure Act is page 537, my lady. And the title of this provision is Protecting from Nuisances, Towns and Village Greens and Allotments for Exercise and Recreation, where it's expedient to provide some means of preventing nuisances. So it's clear what Parliament has in mind here is the prevention of public nuisances, and these provisions are clarifying what Parliament is saying clearly amounts to a public nuisance.
But no, it's the second step I find more difficult. My Lord Sales wants to ask a question, but it doesn't say this is a criminal offence for a nuisance. It's a new offence. It's a new specific offence. Anyway, that's what I'm asking you to help me on. But when it's appropriate, I'd be grateful for some assistance.
I quite accept it's a new specific offence, but the offence created with reference to public nuisances, and that informs the construction of the offence, we say. Lord Sales.
Ms. Charlotte, I wanted to ask, what was the basis on which, as I understand it, the common law offence of public nuisance would have been prosecuted at the time of this statute? So we see that this is to deal with summary means of preventing nuisances. If you had a case based on a criminal prosecution for public nuisance, would that have followed a different criminal procedure?
My lord, I'm afraid I don't know the answer to that question. I'll try and find it out over the short adjournment, but I'm afraid I don't know.
Just to explain, the reason that I raise it is that a possible explanation why the Section 12 was enacted is not, if you like, to displace underlying ideas of public nuisance, but to provide a more efficient procedural route for prosecutions to be brought in respect of something which might be a public nuisance.
Yes, my lord, I can't confirm that is the case, but that would accord with our broad reading of the provision, but we'll try and look into that over the short adjournment.
Thank you.
There are various things you have to show for a public nuisance under the general laws, such as that a significant number of members of the class were affected and so on. So this was definitely a new offence, and as you have accepted, I think it was a felony before. Public nuisance.
I'm afraid my knowledge of Victorian criminal law is my knowledge of modern criminal law is limited, but my knowledge of Victorian criminal law is non-existent pretty much. So I'm afraid I can't take it any further. We say, as a matter of the ordinary principles of statutory construction, legislation should be read and applied in the common law context. This is especially where the statute expressly refers to a concept recognised in common law. We say, in designating acts as instances of public nuisance, Parliament must have intended, in the absence of a clear expression to the contrary, that the prohibited acts would be recognisable as species of the established common law offence. As the Court of Appeal observed in this case, it's a fundamental element of that offence that the act is not warranted by law. The fundamental element because the offence would make little sense without it. The next point I want to make sort of relates to the need to construe the Victorian statutes within their relevant statutory context. They shouldn't be interpreted in a vacuum, but rather in light of the concept of TVGs contained in the Commons Act 2006. Under that act, the governing concept of that sets out the governing concept of what a TVG actually is. The Victorian statutes only become operative once the concept of a TVG is realised. In the statutory scheme of TVGs contained in the 2006 Act, the means by which the concept is realised is registration. Section 15 is therefore logically the primary provision around which other statutes concerning TVGs operate. The appellant's suggested approach replaces the Victorian statutes on a pedestal and ignores the very basis of the concept of a TGV, puts the cart before the horse. The relevance of this statutory point is as follows. The main substantive requirement of Section 15 of the Commons Act 2016 is that local inhabitants use for recreational purposes as of right. Part of the ratio of this court's decision in Lewis, that use can be as of right when it coexisted with the landowner's use. The Court of Appeal in this case was therefore correct to recognise that the principles of coexistence are an intrinsic feature of the scheme provided by Section 15. In other words, it's an inherent concept provided by the 2006 Act that a TVG can exist and be registered where the landowner's use and the local inhabitant's use as the right exist side by side. The control mechanisms are contained within the meaning of the concept as of right. There is no further test. As the court below recognised, this must inform the interpretation of the Victorian statute. It would be odd for the Victorian statutes being contingent on the 2006 Act to criminalise something which the 2006 Act permits. My lady, I see the time. I was going to move on to a new point. I'm still confident I'm going to finish within time, if that's a convenient place to stop.
It is, if that would suit you. Thank you very much indeed. We'll resume at 2 o'clock then. Thank you.
My lady.